Welcome back to the Law News Network. I'm Jesse Weber. You're watching prior testimony in the Adrian Loya case out of Massachusetts. And for those of you who are just joining us and want a little update about this case, or for those of you who are already familiar with this case but want to recap as well, Loya is a former Coast Guard member who's accused of forcibly entering the home of Petty Officer Lisa Trubnikova and her wife, Petty Officer Anna Trubnikova. And then he went on a shooting rampage, killing Lisa, injuring Anna, as well as responding officer Jared McDonald. Prosecutors said Loya videotaped his rampage with a camera attached to his clothing, and then he set explosive devices around the condominium to prevent police from entering the area and responding to the situation. He's been charged with 30 counts in his original indictment, including murder. Now, he has been remanded to Bridgewater State Hospital for the last 2 years. It's a mental health facility as he awaits his trial, as he's now in trial. He was previously deemed competent to stand trial, but his defense attorney, Drew Segadelli, is arguing the insanity defense. Now, what does that mean? That means that he suffered from some mental disease or defect, and because of that, he is not criminally responsible because he was not able to understand or appreciate the wrongfulness of his actions. In fact, the defense has even suggested that he might have autism or Asperger's. So this is a very interesting legal standard, and we're talking about state of mind and intent. So we have with us a very special guest, attorney Pierre Gooding. Great to see you, Pierre, and welcome to Law News Network.
Great to be here. Thanks for having me.
Of course. Much better than Ken Belkin, that last guest. So let's talk a little bit about the mental state. I talked to Ken about it. He made some great points about this. My biggest issue, I think we talked about it, you can't say that you don't understand the wrongfulness of your actions when you knew the police were going to come and you created a barrier to their entry. What do you think about that?
I think that's right. I think the defense is going to have a very hard time, difficult time, proving that the defendant had a problem with his mental state or could not appreciate the wrongfulness of what he was doing because he was setting up explosive devices around the crime scene before he set foot into the home. And so when you have those aspects of premeditation where you are sort of setting up to do the crime, it shows that you sort of knew what you were doing and that you knew that help would be on the way. And so I believe the defense is going to have a difficult time getting around those facts, and that the jury may see through this defense.
Yeah, Ken said earlier that he would give his right arm if he thought he thinks he's going to be convicted. There's no way he'd bet his right arm on it. I tend to agree because we've seen cases before where even if you have a person with delusions, there was one case that I keep bringing it up because it's driving me nuts that, no pun intended, Michael Muko McDermott this is out of Massachusetts. He shot and killed 7 co-workers in Wakefield, Massachusetts back in December 2000. He said he traveled back in time and killed Hitler and the last 6 Nazis. He wasn't found criminally insane. He was found guilty. Every jury's different, but here you have a guy who was in the Coast Guard. I don't know if he had a history of mental illness. I didn't see anything like that. How does that work here? Sure. I don't see it.
It is a high bar to begin with to prove insanity as a defense. And so in this case where you have a community member who was high functioning before this happened, wrote a manifesto 2 years before the crime was committed, I think these are facts that are going to be very difficult to get around in terms of showing that this individual sort of went off the wall or had some reason that he couldn't appreciate the wrongfulness of his acts. Now, the defense is saying that there was a sexual assault. Now, if that is where the line they're going to go down in terms of defense, then not only do they have to prove that there was that assault, they also have to show that that contributed appreciably to the defendant losing the ability to appreciate the wrongfulness of his acts. So a lot of layers to get through even with that defense out there, and that's not even established that the assault actually occurred. So a lot to get through, but as one of the individuals who was on your program a few days ago said, you have to have some defense, and so they're not going to go into a trial without anything, and so this is their best shot.
Pierre, wouldn't it be better if that sexual assault never happened and he thought it happened? In other words, if he thought it was a delusion? I don't know if it's true or not, but wouldn't it be better for the defense to say, this is a guy who thought that this woman sexually assaulted him, and in his delusional mind, he went on a revenge killing? Wouldn't that have been better?
Look, that's certainly an avenue to go down now. Of course, the defense is working with a set of real facts, and if this is what actually occurred, that's what they have to present. If the defendant had thought that an assault occurred when it actually did not, it would surely show a level of not understanding what's going on around you in reality. But the defense has to work with a set of facts that it has, and if the defendant actually told his attorney that this assault occurred and believes that, that's what they have to go with. They can't make the facts up.
No, I 100% agree with you. Let's play a little thing here, a little game where if I was having premeditation on one hand and insanity on the other, do you see that if there was more level of premeditation, in the sense that this is a guy who really knew what he was doing, he planned it out, he was armed for battle, he drove all the way to Massachusetts. The more pre-planned this is, the more calculated, does the insanity lower a little bit, that shows maybe this guy really he knew what he was doing, he appreciated it, or do you not see that connection?
I do. I think the jury are human beings, and they're going to look at this case in terms of the whole set of facts. And if you are planning, you go with a GoPro to a person's house and you write a 250-page manifesto about the reasons why you're upset and what you plan to do, and then you videotape those individuals for months before the act occurs, and then you set up IEDs around the home. All of this goes into account, and so when that planning is happening and the jury is hearing about that planning happening, the jury member, he or she, is going to take that into account, and is going to probably have a hard time convincing himself or herself that this was not premeditated murder and nothing less or nothing more. That first-degree charge, I believe, is going to stick.
Before we go into another clip, I just want to ask you one more question. Let's talk about that 250-page essay that apparently Adrian Loya wrote explaining why he wanted to kill Petty Officer Lisa Trubinikova. If you're the prosecution, what would you love to show about that 250-page essay? And if you're the defense who's trying to claim insanity, what would you love to see about that 250-page essay?
For the prosecution, you show, look, this individual had the time to sit down, write this well-thought-out piece about what he was going to do and why he was going to do it. This is a very cold, calculating, manipulative individual, as opposed to someone who is unable to appreciate the wrongfulness of his acts. If you're the defense, you look at the same words and present the exact opposite analysis. You say the sentences didn't have periods, no sane individual would ever take this course of action, write these things out. Why would you tell anybody what you were planning to do? If you are a sane individual, you hide those things. You don't have it out in the open for everyone to sort of see exactly what you're going to do. And so that's how that manifesto is going to be used on both sides, and it's going to be up to the jury to determine who they believe.
Very well said, very well said. Well, we'll have to see what happens with that manifesto. So we are going to continue our coverage. We will have live coverage of this case a little bit later. The jury is on a site visit of the condominium where the events took place. We're going to turn back to our testimony, prior testimony of neighbor Jameson Cormier, talk about what he heard and saw when this whole event took place 2 years ago. I will be signing off. Misty Maris will be signing in, so thank you for joining me. Stick around. We have Pierre Gooding still here to talk to us a little bit more about this case. But in the meantime, take a look now at Jameson Cormier testimony, and thank you again for joining us on the LawNewz Network.
The opportunity to read it before you came in today.
I did, yes.
That was a yes.
Yes.
Right. And you indicated you heard some canine dogs barking, right? You heard some officers say something to the effect of put your hands up.
Correct.
You couldn't see anything going on, now you're hearing this, right?
Correct.
And in your words, followed by a barrage, your words of gunfire, right?
Correct.
Is that what you just referred to, Mr. Donovan, as 14 rapid fire? Is that your barrage?
Correct.
Okay. So again, you hear the dogs, the barrage, we now know was 14 rapid gunfire, right?
Correct.
Upon the cease, upon the 14th stopping, you here put your hands up, right?
Not immediately after.
A barrage of gunfire, once the gunfire ceased, just to yourself, please don't, you read it today, but just to yourself, once, just raise your hand when you're done.
Correct.
Right? And this is what you did that day. It's fair to assume your memory's a lot better that very day than it is 30 months later, right?
Correct.
Right? And again, sir, having read that, does it refresh your recollection?
Correct.
It does. Okay, and you indicated in the statement wrote 30 months ago, after the barrage, we told us to say 14 rapid fire. The next thing you, once the gunfire ceased, I heard people yelling, put your hands up. Right?
Correct.
Okay, so again, the rapid fire ceases, put your hands up. That's what you remember that night, right?
It was not directly after. There was some.
Okay, well, you want to correct in the statement that you did 30 months ago, that people like this is wrong.
That is not incorrect, no.
Okay, so you stand by that. Put your hands up after the gunfire, quote, had ceased. You said ceased, it stopped, right?
Correct.
Nothing further, Judge.
Anything further of this gentleman? No. Thank you, sir. You may step aside. Thank you.
And how long have you been with the state police?
Approximately 24 and a half years.
And what is your current assignment within the state police?
I am the commander of the State Police Bomb Squad.
And what duties does that entail?
24/7 coverage throughout the Commonwealth for any incidents regarding explosives, explosive-related hazards, military ordnance, booby traps, hoax devices, or destructive devices.
And how long have you been with the bomb squad?
I've been with the Bomb Squad for over 19 years.
Now, drawing your attention, sir, to the date of Thursday, February 5th of 2015, do you recall coming down to the Cape?
Yes, sir.
And do you remember why?
Yes, sir. I received a call at approximately 2:40 in the morning from one of my sergeants at the time to advise me that Bourne PD and Bourne Fire were requesting our services, the State Police Bomb Squad, for what they believed to be a device that was located at a scene.
And did you get the address of that scene?
I did, sir.
And what did you do?
So at that point in time, I responded to Bourne to the address given, and while I was en route, I contacted State Police Middleborough, which is the headquarters for that particular area, to gain further information so that when I arrived on scene, I had the full situational awareness. While en route, I was advised that there was potentially an active shooter situation, and not just one device, but potentially secondary or tertiary, second or third devices. So as I was responding, I was getting a mental image of what I was going to encounter when I arrived on scene.
And where were you coming from?
Plymouth.
What happened when you arrived?
So I arrived at 3:30 in the morning. I arrived on scene, and at that point in time, I observed a large amount of police presence, police activity, ambulances, and also I observed a charred vehicle sort of blocking the road. And that's where I parked.
So when you observed the vehicle, again, could you describe the condition of that vehicle?
Yes, sir. So I observed a vehicle, a sedan, if you will, that was smoking, charred, blocking the path of this road in a horizontal fashion, with really no way to go around that.
If you can kind of look at this photo board, and can you identify what's depicted on the pictures on the board?
Yes, sir. That is a vehicle in question, blocking the road in question that I arrived on.
And are these fair and accurate depictions of how that item looked when you saw that?
Yes, sir.
And I offer this as an example.
No objection.
X numbers of
Just a second, just to show you. And you got there, you said about 3:30?
Yes, sir.
And you indicated that there was still smoke coming from?
Yes, sir.
And I think you've already said this, but could you please describe for the jurors how that car was located on the roadway that it was on?
Yes, sir. So if you picture a road running, say, north and south, the vehicle is placed east and west. So as a blocking pattern, if you will, potentially prevent other vehicles from going around.
What's the next thing that you did, sir?
Exited my cruiser and approached the group of officers that I believe to be the incident command post, that situation or scene. And I was advised by a senior ranking Bourne police officer who I don't have a name, at that point in time advised me that there were potentially devices.
Hold on.
He advised you, but he did.
Okay, so just listen to me for a second. Just yes or no. Did you have conversation with that individual from Bourne?
Yes, sir.
As a result of that conversation, did you then do something?
Yes, sir.
What did you do?
So at that point in time, I called for my second bomb technician who was responding to give me assistance based upon the information that I was given, and then started to formulate a plan as to how I was going to approach these potential devices.
What's the next thing that happened?
Next thing that happened was the chief of police from Bourne PD approached me and advised me that he would lead me through the scene of the items that were identified as potentially harmful and threatening.
And what's the next thing that took place?
At that point in time, I went back to my cruiser. I secured a large amount of glow sticks, red and green, to indicate hazards or non-hazards of these items as I did my threat assessment. I was still waiting for my second bomb technician to show up, but I had to take immediate action based upon the large amount of people that were there.
This may seem like an obvious question, but what would the red glow stick mean?
A red glow stick would indicate a hazard.
In the
Do not
green?
go near that.
In the green?
Green, non-hazard, benign.
Okay. So what's the next thing that you did?
At that point in time, I proceeded to the first device in question.
And where was that?
That was approximately 5 meters south of that burned vehicle, next to a buried fire hydrant.
And buried by what?
Snow.
Okay. And could you describe what you saw?
Absolutely. I approached this device in question. It appeared to me to be two 2-liter soda bottles taped together with silver purple tape. And there was a metallic object also attached to it with multiple wires leading from that metallic object, and then a PMR, personal mobile radio, Motorola, that was attached as well on the exterior of these 2 bottles.
If you'd like to use this, please feel free to. I'd like to show you something that's been marked as an exhibit. Exhibit number 2. Do you recognize what this is? Take it.
Yes, sir.
Could you take that out of the bag so the jurors can see it?
Absolutely, sir.
Is that the item you were talking about?
Yes, sir.
And if you could describe for us, what is it that you did or what significance did that have for you? You already mentioned, I'm sorry, but you mentioned 2 soda bottles, so if you could just start with that and just go on.
All right, so at that point in time, sir, I approached the item in question. Again, this was to market and to get situational awareness. I did not have my second bomb technician with me at the time. So I wanted to make sure that we were somewhat in a safe manner to bypass it, mark it and bypass it. I didn't want this to spontaneously detonate or explode, putting other people at jeopardy. So I approached the item. I noticed that the PMR, the Motorola radio, was in the on position. There was a numerical indicator on the front. I looked at the item in question, and also I had knowledge that there was a subject potentially taken into custody. So at that point in time, doing my threat assessment, I realized I'm going to mark this as a hazard. Hopefully, the individual that was on the other end of this radio was not able to function the item and cause it to go off. Marked it as a hazard.
And is that what that red glow stick right there is?
Yes, sir.
Okay, go ahead.
So, again, after I inspected it to make sure that it wasn't going to spontaneously detonate, I moved on to the next one.
Okay. And what did you, when you observed that, you started to say what you saw inside the soda bottles. What did you observe?
So, approximately halfway up on the soda bottle, I observed multicolored items, appeared to be solid items or solid objects consistent with candy inside there. There was no liquid, There was not one particular matter. It was multiple items colored that were consistent with Keenan.
And when you first observed that, without being able to take a closer look, did you have concern for whether it was or wasn't? I'm sorry, whether it was an explosive device?
Are you objecting on some foundational basis?
Yeah.
Oh, all right. Objections withdrawn.
So based upon my knowledge, training, and experience, I looked at this as still a potential threat, but I had not diagnosed it fully, but I had to move on to the others.
You can just look at this. Is that item depicted in A and B?
It is, sir.
Now, those are average pictures of A and B?
Yes, sir.
In C, what would C be?
C would be the Motorola personal mobile radio.
Is that how that looked on that night?
After I detached it, sir. Yes.
Showing in which item?
This would be B for ID.
Thank you.
It's B for ID. If you put that back
Yes, sir.
in. Bring it back. So after your preliminary examination of that item, what's the next thing that you did?
After I marked that item, I then proceeded with the police chief to the second item in question.
And where was that located?
That was approximately 50 meters south of the residence in question,
And the residence in question would be what?
11 Roundhouse Road.
Okay. So this would have been from where, let me just ask you this, if you could look at it.
Good morning, everyone. I'm Misty Maris. Welcome to the LawNewz Network. We're here in the Adrian Loya case. I know that we've been watching some clips this morning. This is quite an interesting case. We're going to be live in the courtroom later today. Right now, the jury is on a visit to the site where this heinous crime occurred. So just to reacclimate everybody, this is the trial of a Coast Guard member, Adrian Loya, who's accused of killing a fellow Coast Guard member. But this is not your average murder. This is what seems to be a really heavily planned, heavily prepared for murder. We have somebody who came to this woman's house. He had a GoPro on. He was looking to tape this entire occurrence. He had a manifesto relating to the crime. There are just so many facts here. It's going to be such an interesting trial as it unfolds. Prosecution obviously says this is a planned and premeditated murder. Defense has a different story. They're raising the insanity defense. Insanity in the state of Massachusetts is that the defendant did not know or understand the criminality of his conduct. So that's going to be the arguments we'll see unfolding today. Right now, jury at the site inspection, but we really need to break this down. And to do that, I have Pierre Gooding. He's an attorney. Pierre, first of all, let's talk a little bit about what it means to go on a site inspection.
Sure.
So in some cases, it's very critical to see where the crime occurred. There's a lot of different reasons. And often, you have to ask the judge. You have to actually make a motion to the judge and say, hey, we need to bring the jury out to the site inspection. It's actually a pretty big ordeal. And oftentimes, judges say no. Yep. In this case, the judge said yes. We've seen cases where maybe the terrain matters. Maybe it's critical to show where the crime occurred because you might be able to raise some doubt based on the location. Yep. But in this case, why do you think the site inspection was relevant?
Well, Misty, I go back to the O.J. Simpson trial a couple decades ago in terms of looking at site visits and why they're so important. There, the jury was trying to determine could O.J. Simpson possibly make it from his house to the scene of the crime in the amount of time that the prosecution was alleging. And so it was important for the defense to have that site visit to raise that reasonable doubt. Here is a different circumstance. We know for a fact the prosecution and defense are of the same mind that this crime occurred and the facts are not at issue. And so when the jury goes and sees where those IEDs were planted and sees where the victim was shot and where her mate was also shot, I believe there is going to be a level aggravation there from the jury. They're going to be upset, and so I think that the defense is going to have a very difficult time getting around those facts. And why do you do it, Misty? You do it so that the jury can appreciate what happened in real time. They can see exactly for themselves where things were situated, where people were, where the witnesses were, so that they can determine for themselves who is telling the truth and whether the defendant actually did appreciate what was going on. If he's setting up all of these contraptions around the scene, does that say to you, I knew what I was doing, I knew that the police officers were going to arrive, and I'm doing this in anticipation of that? Or does it say something else? And that's what the jury has to determine.
Yeah, I think you make such a great point, Pierre. All of those facts are really going to be relevant in this case. And when you go to the site, very often that is important because you can look around, you can see where everything is situated, see where the crime occurred, see what the outside is like. Say you have a break-in or something like that. We're talking about O.J. Simpson. Obviously, the critical element there was, could he have even gotten to the house in time? There was an argument to be made. But in this case, it almost seems like the defense is going to have an extra hurdle.
Yes.
So break down some of these facts. So we have these bombs, and
Yes.
the police didn't know. We heard from the bomb squad 2 days ago. They didn't know whether or not the bombs that the defendant had placed around the property were real, or if they were fake.
Exactly.
There was also a burning car that was placed in an area seeming to block the ability of first responders, of medics getting to the house to respond to the crime. And then you have this music playing. You have all sorts of facts that really tend to show that this was planned and prepared for. Now, when the jury steps into that house, I'm sure they're going to be saying, okay, bombs placed here, car placed here. There was some information that the defendant had looked on Zillow or some other sort of internet website to see the format of the house, looking at the rooms. I mean, this is a big hurdle for the defense. This site inspection doesn't seem like it's going to help them much.
No, it does not, Misty. And think about the facts that you just laid out. The fact that you placed or allegedly placed fake explosive devices around the site indicates that not only did you know that help was on the way, you wanted confusion so that police officers were stopped from coming to the site expeditiously quickly. So that's a real challenge that the jury is going to be internalizing this data, internalizing this information, and looking and saying, this doesn't add up. If you are saying that you have a mental defect or that you are criminally insane, why is it that you were able to take the time to do all of these things, to strap a GoPro onto your person, to strap a video camera into the trees, and look into these individuals' lives for months at a time? This indicates a level of planning, a level of lucidness that I believe the defense is going to have a very difficult time to overcoming, as you stated.
Yeah, I totally agree with you, Pierre. But let's talk a little bit about what that legal standard is, because maybe we're missing something. And obviously, as the trial unfolds, we don't know what's to come. We're obviously going to be hearing from medical experts regarding the defendant's state of mind. Also, one important thing to remember when you're talking about an insanity defense, and this is often something that's time and time again really the focus of the defense, is that you're looking at that person's state of mind at the time the crime was committed. So things that happened before and things that happen after are relevant for the purpose of what does that mean for their state of mind. But the question is, at the time that the crime was committed, and in Massachusetts, they use the Model Penal Code definition of insanity, which is that the defendant did not know or understand the criminality of their conduct. So that's one piece of the puzzle. Now, the question is, who has the burden to prove that? And in Massachusetts, it's the prosecution.
Yes.
Which is interesting. In New York, it's different.
Yes.
And as a New York lawyer, it's always your burden as the defendant to raise that as an affirmative defense and prove that your client, the defendant, did not have the mental capacity to commit the crime. Well, here, the burden's on the prosecution to prove that. So that's actually a tougher burden for the prosecution, because now they not only have to prove the crime beyond a reasonable doubt, but they also have to prove that the defendant was mentally capable of committing the crime and falls within falls within the definition that they were actually had the capacity to commit the crime. So that's a factor that's going to be relevant here. Pierre, how do you think that's going to play out?
Missy, you're absolutely right. Adding an additional layer in any case to sort of prove the elements of the case is difficult. But the problem for the defense here, I feel, are the actions that were committed prior to the crime. So when you set up those IEDs and when you set up a situation where you are actively trying to make sure that help cannot get to where it needs to get to, you are able, in my legal opinion, humble opinion, able to appreciate the criminality of your actions. By definition, you know that help is going to come, and so you are trying to make sure that that help is blocked from passing through physically and literally blocked. So I believe that the defendant has set himself up for failure here by his own actions. In writing that manifesto, I think it's going to be much easier for the jury to say, this is someone who had an axe to grind, someone who was romantically interested, some other reason besides not being able to appreciate the criminality of your actions. That does not seem to be at issue here.
Right, Pierre, you made so many great points there, and I want to talk a little bit more about that manifesto. So we don't have a copy of that right now. That's going to come out in the course of the trial. Obviously, from what we've seen, the information that's out there right now, the manifesto really lays out his intent to commit this crime, his intent to kill this woman, which such a tragic event. But what do you think about, isn't it really what is in that manifesto, the wording of that manifesto, that may speak to both sides of the coin? So on one hand, who knows what that thing says? Maybe that will speak to the fact that he was not capable of actually understanding his conduct, that he was so far gone, not lucid. Or it could go the other way. And that fact that you brought up very astutely is that this seems to be, according to a statement made to the police and what we know is in this manifesto, it's actually a revenge crime, seeking retribution. There was some sort of either romantic relationship or romantic interest, or we've also heard that there's some indication that the defendant had said that he was abused at the hands of this woman at some point while they were in the Coast Guard together. But doesn't that completely undercut an insanity defense? Now you're talking about revenge.
Misty, absolutely. And the defense is going to have to be very careful here to not, as you said, undercut its own defense by stating that the sexual assault is the reason, the main reason for the defendant committing this crime allegedly. Well, now, if it's a revenge killing, that has nothing to do with insanity. It has nothing to do with being able to appreciate the criminality, the criminal nature of this act. And so you not only have to say that the sexual assault occurred, you have to show that it contributed appreciably to the defendant losing his ability to control his own actions and understand what he was doing. And so that's a very, very difficult argument to present to a jury successfully. And I do believe that the defense is going to be in some trouble if they continue to go down that road exclusively.
Yeah, Pierre, you are completely on point there, because many times in these cases, when you're talking about successful insanity defenses, and gosh, they're tough. No matter what the facts are, insanity defenses are tough because it's hard for a jury to wrap their mind around that this person is not culpable for their actions because of a mental disease or defect. So very oftentimes when these defenses actually succeed, you have someone who's really so detached from reality that it's pretty objectively clear that they are not able to formulate right from wrong or understand the nature and consequences of their action, whatever that legal definition might be. One person that comes to mind to me is Andrea Yates, and I don't know if you remember this case, but she drowned her 5 children. She was actually convicted by a jury. That conviction was overturned, and it was changed to insanity later on based on, there was an issue with the prosecution, there was an issue with an expert, but in the end, she's now in an institution getting mental help. She's committed there for likely the rest of her life. But in that case, she was convinced, her testimony was she thought she was possessed by the devil and she was saving her children from being, from hell, essentially. And so those are the types of cases, those are the types of facts. Not to say, again, a jury convicted her.
Yeah,
So,
absolutely.
and then that got
Even there.
reversed, and then there was more to it. But it's very difficult to have a successful insanity defense. It's even more difficult with facts like this, because oftentimes you're looking, what happened beforehand? What happened after? Cases where somebody comes out and they're like, I don't remember what, somebody died, I don't know what happened in there. Those are the types of cases where you might have that line and you've got a good argument to the jury, but the defense here, is this defense being set forth just because it's really all they got?
Well, Missy, a couple of points. The insanity defense is a very high bar defense on purpose. We do not want every individual claiming mental insanity on the back end after a crime is committed. But especially here, if you take a look at the set of facts that the defense is working with, there's no doubt that the defendant actually engaged in these acts. It's on tape. It's on GoPro.
Yeah, by his own doing.
By his own doing.
This isn't even a surveillance camera or something.
It's his own GoPro. So when you're dealing with you can only deal with the set of facts that you have, and the defense has a case in front of them. Every person is entitled to a defense, and so they're taking a look at it and saying, could a sane person do this? We have our doubts, and maybe the jury does as well. It's unfortunate, but the specific set of facts here make it look as though the individual was in fact aware of what he was doing, but that's for a jury to decide, and that's the defense has to put forward some presentation, and this is the best that they have.
Yeah, that's definitely true. It's sometimes lawyers, we don't create the facts, right? We just take the facts and we put forth the best defense or best prosecution, whatever that may be. And in this case, I think you're right. Likely, there really just isn't anything else because a lot of this is uncontested. And that's because, number one, as you pointed out, there's that GoPro. Exactly. There's this tape that he strapped to purposefully to record what happened. Yeah. Then you also have two living witnesses. You have two victims who are alive. So what's the impact of that? So now you have two people who were there, who are going to testify to the circumstances.
And the victim's significant other, that is going to be some very powerful testimony. When you have an individual who was right in the room, saw her spouse be slain in cold blood, that is going to be some very powerful testimony. You have the officer who was shot during the rampage after the initial shooting. These facts are, as you said, uncontroverted, and when the jury has the chance to see these individuals firsthand and hear what happened, I believe it's going to be very powerful. And for the defense, it's going to be a difficult cross, because what do you have to actually cross these individuals on? As you said, the facts are not in dispute. So, the character is not in dispute. What is it that we're actually talking about besides what happened? These individuals are not going to have the capacity to speak to the defendant's mental state. So very difficult crosses are going to be coming up for the defense. And this case is very difficult because the defendant was so specific in what he was doing leading up to what happened on that tragic night.
Yeah, absolutely. And that's really where the defense is going to have their uphill battle. I think that what we're going to see, probably a focus on the second part of that insanity definition. So it's not just enough to say that the defendant knew what he was doing. He has to also understand it. Yes. From what we know right now, that seems to be a very tough road, because after the defendant came out, we know that he had set this car, knowing that people were going to respond, knowing that, trying to block that. Those types of facts, the way that somebody reacts after the fact, is very often indicative of their mental state during the time the crime was committed. Probably the most damaging thing here is that statement made to police right after the fact, where he explained that he had been abused or there had been some issue with the victim in the past. Because now you've set the stage to say, well, you did not you didn't not know what you were doing. You knew what you were doing, and you understood what you were doing because you did it for revenge.
Exactly.
Now, I don't know what happened in any pretrial motions, but as a defense attorney, I would have tried to get that out if I could.
Well, and this is the road that the defense has gone down already. The defense has stated that a sexual assault occurred by the defendant's own admission. And so now you're in a situation where you have to make sure that that accusation plays into your mental state or that defense. The argument is once that occurred, it was the tipping point. It was the thing that set this individual off or over the top, so that he felt that this was the right thing to do or what have you. But you're right. There's a very fine line between stating that the sexual assault, the alleged sexual assault, was the reason that this individual snapped, and saying this was the reason for the killing, because a revenge killing, as you said, has nothing to do with criminal insanity, a mental defect, and in fact would be a reason independently to put this individual away for first-degree murder. So I believe that the defense has a very tough time, and this sexual assault charge could be as harmful as it is helpful.
Yeah, I agree with you. I was actually surprised that there was any focus on that, on the defense point of view, because one thing that is so critical here is to show that some sort of mental disease or defect made this person unable to appreciate the consequences of their actions, made them not able to understand and know what they were doing was wrong. So maybe we're going to see, I'm putting my defense hat on right now. Maybe we're going to see the defense say, well, hey, it's because he suffered this abuse that he snapped in this moment. Yes, we know that he did have some sort of idea of what he was doing. Obviously, he knew that he was putting these bombs down. Obviously, he knew he was taping it, but he did not understand. And that's probably going to be where the defense goes. It's going to be a focus on the defendant's ability to understand, because that aspect of knowing, these facts do not tend to negate to show that the defendant didn't know what he was doing. It's just, did he understand it? So that's going to be a huge piece for the defense. Loop that back with the defense opening statement, which we watched a little bit earlier today. We saw the defense attorney focus on the fact that the defendant is maybe on the autism spectrum, has some sort of issue. Perhaps he's going to couple those together. The abuse plus that diagnosis led him to the inability to really understand the consequences of his actions. Now, that being said, we know that the medical definition of something that a mental defect or some sort of incapacity is different than the legal definition. So just because you're diagnosed with something, some sort of medical issue, does not mean that you have a rock-solid insanity defense.
Yeah, and let's be very careful because of what you just said. Let's say someone was determined to be autistic. In 99 out of 100 cases, that person would be deemed to be competent to stand trial because autism does not make you unable to appreciate the criminal nature of your actions. That is a very high standard where you're basically talking about an infantile sort of state of mind to not be able to know, okay, I hit somebody. I didn't know that was a battery because I am 4 years old, or I am in a state where I cannot sort of think on a high level. This is not that situation. This individual was clearly high functioning before the situation, was high functioning while the planning of the situation occurred, and some would say after, while talking to police officers in a very calm, cool, collective manner. Does that show a level of possibly being a sociopath? Yes, but not a level of not understanding what you're doing.
Right, that's why I found it very interesting that the defense attorney brought that up in the opening and put focus on it, because this is, realistically, when you're talking about autism, there's geniuses. I mean, many people, certainly not murderers, and I'm wondering what the purpose was there, but perhaps it's looping that in with something else that led him to that inability, the legal definition of insanity.
It's that reasonable doubt. If you say, look, the guy has autism. He was already dealing with some challenges on the front end. Then he was sexually assaulted by the victim. at some point he snapped and created this manifesto, and all of these things that happened were a manifestation of these actions as opposed to the causal error going the other way. It's about causing some confusion for the jurors, introducing some doubt so that they have something to hang their hat on. Because if you just look at the facts on their face, there's very little to sort of say, no, this individual shouldn't go to jail for life. But if you start introducing these aspects and then you get into a situation where the prosecution, if they make a mistake and go down the rabbit hole of trying to prove that this assault never happened, well, now you're sort of wading away from the issues that matter. And so the point for the defense is raise as much confusion in that courtroom, raise as much doubt as possible, given the set of facts that they have. It's just a very difficult case for the defense to work with.
Pierre, I think you very articulately just described exactly what the defense is going to do. I think that's their roadmap. Absolutely, that there was this issue that he was already, because he had been diagnosed with some sort of mental disease, that he was already a little bit vulnerable, and then there was this abuse, and all that combined together led him to snap, that this manifesto and everything moving forward through the crime was all a part of that issue, that lack of capacity to understand, and I think we're going to see that as the focus. One issue, somebody brought this up, another guest made the point. So the defendant is in the Coast Guard, and we would imagine that in that position there would at some point be some sort of mental evaluations done.
Absolutely.
And that if somebody was very far outside of the realm of reality, if someone really didn't know or understand the consequences of their action, that might come to light. More so than the average Joe who's not subject to a medical or mental evaluations outside of a doctor's visit or something. So that could play a factor. And are we going to see those records?
I believe they will come out during the course of the trial, but that is a key point, Missy, that you just made. All of these things come into play. The fact that the defendant was a member of the Coast Guard means that we will have some medical evaluations at some point, and what will be damning to the defendant is if those medical records don't show much, which they may or may not. We will have to wait and see, but those records will come out during the course of the trial, along with the manifesto, and the jury and the public will get to see more aspects of this case. But for right now, for what we're viewing, it looks like it's going to be very difficult, even as you wade through that manifesto. From what we know of what's in the manifesto, it sounds like an admission, a flat-out 250-page admission that I'm going to do this. These are the reasons why, and really, you couldn't have more damning facts if you're a defense attorney trying to make sure your client stays out of jail. So it's just a very difficult set of facts for the defense and for the prosecution. Really, it's about making sure you stay the course and not wade into some of these other aspects that may confuse the jury.
Yeah, you're right. And that manifesto, that's going to be a key critical piece of evidence. And what we're likely going to see is relevance on both sides. So from the prosecution's perspective, they're going to say, based on what we know, again, we have not read or seen the entirety of it, so we don't actually know the content. We just know it's been reported.
Exactly.
But it appears to be akin to a confession, as you said, so the prosecution's definitely going to have that spin. Yeah. The question is, the defense, are they going to have an opposite? Well, I think we can guarantee that they're going to have an opposite perspective. Yeah. That's likely going to be that this manifesto indicates somebody who's not with it, who's just devoid of reality, and they're likely going to have a medical expert on the stand who will testify. So are we going to have a battle of the experts here? Is that what this is really going to come down to?
Absolutely. The prosecution will need to, by law, actually have an expert to help establish or the defense, rather, will need to have an expert to help establish that mental insanity defense. So we will certainly see experts. The defense is going to have to parade a mountain of experts to sort of counteract the hard facts of the case. And from the prosecution side, they already have analyzed the defendant and determined that he was competent to stand trial, and so I'm sure they will introduce that analysis, and we'll go from there. But the jury will have a mountain of expert analysis to go through as each individual is making the decision about whether this defendant is innocent or guilty.
Definitely. I think we're going to have a lot of that. And sometimes medical testimony can really confuse. It can be very difficult to weed through, especially when you have two experts who are very accredited. And that's who you're going to see. You're going to see very accredited experts coming on and having completely opposite perspectives.
Exactly.
And that's for the jury to weigh. I mean, that's one of those questions that the jury is going to have to answer at the end of the day. Pierre, I want to piggyback and go back to another point that you made. I want to talk about the testimony of the victim's wife, who was shot that day but did survive.
Yes.
And how much impact that's going to have. Because not only do you have somebody with an account of the crime, with an account of the horror of someone breaking into your house and attacking. And on top of that, you're also going to have someone with a really strong emotional tie to the victim. And that testimony is probably going to be really very influential to the jury.
I mean, Misty, well, everyone has to understand that the jury is composed of human beings. And so when she takes that stand, and if she does end up crying, it's going to be very powerful. And the jury is going to have to sit through that testimony of her spouse being slain, allegedly, by the defendant. And so that is going to be very powerful television, very powerful testimony. And for the defense, again, I don't know what the cross is. She's not well versed on the defendant's mental state, but she was certainly there when this tragedy was occurring. And so I again feel that the defense is going to have a very tough time either with a cross or putting on counter evidence to sort of counteract what happened in that bedroom on that tragic night. I mean, the facts speak for themselves.
Right, and you're right. When you're talking about a defense cross-examination of a victim, you have to be, as a defense attorney, so careful, because you don't want to make that victim upset. You don't want to be pounding and pounding and pounding on that victim in the way that you might treat a witness hostilely when you're cross-examining them to get the truth. This is a completely different type of cross-examination because the jury does not want to see you berating the victim.
Exactly.
Here, though, my guess would be, and you tell me what you think about this, I'm interested in your opinion, the defense is really going to be asking questions to get down to state of mind. It's not going to be so much about exactly what happened. Prosecution's going to want every single element of what happened. He walked in the door. He knew where to turn. He came in the room. He did X, Y, Z. They're going to set that forth. The defense is going to say, did he seem to be lucid? What did he say? Was he mumbling? Was he yelling? Was there something there that would show that this person was not able to comprehend what was going on? And in that sense, you may get a witness on the stand who said, my gosh, this guy was acting crazy, which, again, that word is such a generalization. That is not a legal term. That is not enough for an insanity defense. But you get enough people up there who say, this guy did not seem to know what was going on. I'm thinking about one of the statements from one of the police officers that responded, who said that the defendant was chillingly calm after the fact.
Yeah.
Now, that speaks to, number one, somebody who's like, okay, great, I've completed what I set out to do. Or, on the defense perspective, somebody who's a little too calm for the rampage that just occurred. So, what do you put those facts together?
Well, Missy, I think you're right. The defense is going to try to flush out the aspects of the case that just seem too unnormal to be happening, right? So when you ask the witness, what type of music did the defendant play? And the answer was he was playing symphony music. Yes, that does tend to lead to an insanity defense. Again, the problem for the defense is going to be not necessarily the testimony in that moment, which will also be charged, but what were the circumstances before and after the tragic event occurred. So again, the fact that there were roadblocks set up, the fact that that statement was made in such a calm manner, these things all add up to circumvent an insanity defense. So even as you start to ask the witnesses about some of the aspects of the defendant's actions in that moment that were not even close to being normal or could be determined to be insane, there are so many circumstances that happened in the days, weeks, and months prior to the incident and then after that it's going to be very difficult to get a witness to say something that is going to lead to a positive outcome in your case. I feel, even with some of the things that the defendant actually ended up doing.
Yeah, I definitely think that you're right. This is a really tough case from a defense perspective. Again, we absolutely know that the defense is putting on the best possible case. I mean, in a case like this, really the insanity defense is where you have to go. A lot of people have that feeling, though, that they say, oh, well, if somebody's committing a murder, then yeah, they probably are a little bit insane. The question is, do you fulfill that legal definition of insanity? And that's really what we're looking for here. And again, that focus is likely going to be on that piece about the understand piece.
Exactly.
Did he understand his actions, the illegality of his actions? A lot of that's going to come down to that manifesto.
Yeah.
When we get that manifesto, we're really going to have an idea about where this case is going. But from a prosecutorial perspective, what do you think? So we know what the prosecution's case is. We know the facts. We know a lot of this is uncontested. Yep. What do you think the focus is going to be? Is it going to be that burning car? Is it going to be those bombs? I mean, the bombs to me are a much bigger piece of this puzzle.
Yeah.
Than they obviously they weren't real.
They weren't real.
But they were there seemingly for the purpose of making it so difficult for medical help to arrive.
Missy, I think you're hitting the nail on the head. That is for the prosecution gold, because you set up the defendant set up a situation where he put down IEDs that were not real. So he knew, well, what's the purpose? What's the purpose of putting these IEDs down? If they're real, you could say, all right, he is doing a lot of things that he doesn't know are wrong, but he's doing them because he's out of control. If you're putting down fake IEDs, can you give me another reason besides attempting to stop medical assistance and police officers for coming to the property? What is the alternative rationale for that? And so I believe you're right. I believe that's an aspect of this case that hasn't been flushed out enough, and I think the case does turn on that fact alone. If you are intentionally ensuring that help cannot be on its way, then are you able to appreciate that you're engaging in a criminal act? I would say yes, and I believe it's a very easy thing for the jury to also determine that that's the situation.
Pierre, think about that. That one fact. If you're taking affirmative action to make sure that no one can respond to this incident, no one can respond to this horrific, basically an ambush.
Exactly.
Then by the very virtue that you did that, you understand that it's criminal.
Exactly.
And that there's going to be police.
Exactly.
And that there's going to be an ambulance.
Exactly.
And that there's going to be a fire truck, and all of that is going to happen.
And I don't understand from a legal definition how you get around that fact alone. What do you sort of say? Well, it has to all be encompassed in the realm of he's lost it, and everything that he's doing is without sort of being lucid or understanding what you're doing at all. And that's a very, I feel, difficult bar for the jury to sort of overcome. For the jury to say, okay, everything that happened for the months leading up to this case was a part of insanity. That's another, the time dynamic is another aspect of it. I believe it's easier for a jury to say, okay, in real time, a situation occurred, this individual lost the ability to understand what he or she was doing, then months before when you are setting up surveillance videos in trees and writing these manifestos and doing this meticulous planning. The premeditation piece does not in any way circumvent the insanity plea, but these jurors are human beings, and when you see the level of planning that went into allegedly this crime being committed, it starts to be very difficult to say that this person was not able to appreciate what he was doing.
Right, Pierre, I'm hoping that the defense attorney listened to you earlier, because I think you did articulate what the defense has to argue,
Yes.
which is that there are these circumstances that made this person vulnerable,
Yes.
that this person snapped into an extended term. Usually when you're a defense attorney, you are hammering home. You're like, don't think about his mental state any other time than during the commission of this crime. That's all we're looking at. Don't look at this. Don't look at that. Just look at this. But in this case, it's a little bit different. You have to justify, you have to say that this person lacked the capacity to understand from the time that they planned this crime to the time that they walked out that door after the fact.
Exactly.
So that has to be the argument, that the understanding element, the understanding the nature of what they were doing, understanding the criminality of the conduct, was not there during that time, and that it's because of this, perhaps the autism issue that was brought up during opening statements, coupled with abuse. Because I will tell you, I thought to myself, I don't know why the defense wants to bring up this abuse, but I think you hit the nail on the head.
No, it has to be a part of a larger strategy of saying this was the tipping point, and unfortunately the victim was the impetus for this tipping point. You're trying to introduce sympathy to what some would argue is probably or likely an unsympathetic jury, and so that is what they must do. It's going to be difficult, but again, the facts are the facts, and the defense has to work with what it has.
Absolutely, and that's what we really, all you can do is work with the facts that you have.
Exactly.
I mean, many times that's something that that people don't understand. You're like, why is the defense doing this, or why is the prosecution doing that? But you're handed a case.
Exactly.
You don't make it up.
You don't make
You
it
have
up.
to just make the best arguments that you can.
Exactly.
And in this case, this was an insanity defense. But Pierre, I don't know the answer to this question because we might not be privy to these types of discussions. But does this seem like the type of case where a good strategy might be to just plead guilty? Or something, or maybe try and get some goodwill with the prosecutor with respect to sentencing or receiving mental health treatment?
You know, Misty, I do not know if the defense really had that as an option. You're going to get life if you plead guilty. And what the defense is trying to do is set up a situation where it's not guilty by reason of temporary insanity or by reason of insanity, so there would be a confinement hearing after that point, and then 6 months after that there would be a reevaluation in every year after that, and so in a few years maybe the defense says this individual has been rehabilitated and is no longer suitable for confinement, and that actually net I feel is a stronger strategy than pleading guilty, because you're going to get life. The set of it was first-degree murder. No district attorney in this country is going to let you off for less than that, given the set of circumstances. So I believe that the insanity defense was all they had.
You're probably right, Pierre. I doubt that there was any sort of option, even in a plea deal here. This crime was just so heinous, and the prosecution really has a lot of ammunition.
Exactly.
So it's going to be really an interesting trial to watch. A lot of legal issues that we're going to see moving forward. Pierre Gooding, stick with me here if you can, because I want to break this down with you more. In the meantime, we're waiting for the jury to return from their site inspection. I want to talk a little bit more with Pierre about what that means and how that's going to give the jury some context moving forward. In the meantime, while we wait, we're going to revisit the prosecution's opening statement. Listen here, because this is a roadmap of where the prosecution intends to go. Now, with some of the testimony that we've heard over the past couple of days, kind of put the pieces together that the direction of the prosecution, and we'll talk a little bit more about how the defense strategy is to poke holes in that case. So we're throwing to the prosecution opening statements now.
The evening of February 4th, 2015, Lisa and Ann Trebekova, a married couple serving their country in the United States Coast Guard, returned home to go to bed. It was a night like any other night, the evidence will show. Only at about 1:30 in the morning of February 5th of 2015, it became a very different night. The evidence will show that at that time, Adrian Thomas Loya blasted his way using a shotgun, 2 rounds fired, through the front door of 11 Meeting House Road, where they live, in Bourne. He scaled the steps up to their second floor bedroom, discarded the shotgun he used to gain entrance, and entered the bedroom where they had been sleeping. He had on his person at that time a handgun and a rifle. The rifle discharged at least 1 round while he was there, and the handgun discharged at least 15 rounds, 11 of which hit and eventually killed Lisa Trebekova. Anna Trebekova was hit or wounded at least 4 separate times. In the arm, in the chest, in the thigh, in one that shattered her humerus, which is also in her arm. Now, my name's Brian Glenn, as I said to you before. With me is Michael Donovan, and also assisting us is going to be Sean Hatch from the State Police with the introduction of the evidence in this case. This is the opportunity that I have to address you with the major outline of what I expect the evidence in this case will show. Nothing that I'm going to say is evidence in the case. The evidence has to come in through the witness. But the way that this case will unfold for you will be through the witnesses. And some of the witnesses may have a very big part in one aspect of the case, and a minor part in a different aspect of the case. So you're going to have to wait until all of the evidence is presented to you to be able to put it all together. And that's one of the reasons the judge had told you before, don't draw any conclusions until after you've heard all of the evidence, because some of the witnesses just won't be in a position to tell you about what happened at one scene, or they'll tell you just bits of what happened at one scene, but they'll be in a great position to tell you about what happened at a different scene. Now, the evidence in this case will show that in the early morning hours of February 5th of 2015, the birthday of Adrian Loya, he went to 11 Roundhouse Road. But before he got to 11 Roundhouse Road, you're going to learn that Roundhouse Road is basically a development of houses, and that there's a singular entry and exit way, and then it's a circle. And that he took his car, which was a Mazda, parked it across the roadway, and set it on fire. And that the intention, the evidence will show, for doing that was to delay the police response to the scene. The evidence will also show, I should say, that a device was left near the car at that same location, the way in or out, to look like a bomb. And you'll see pictures of that, and you can see parts of the device over here, because obviously the police took it apart to make sure that it wasn't in fact a bomb. And it wasn't a bomb. It was a hoax device. You hear that he also took a rifle and placed it under the deck of a house near this area, 21 Roundhouse Road. Now you hear that at this time, February 2nd of 2015, it was a snowy area. It wasn't snowing that night, but there had been snow on the ground. All right. You hear that he went, and right in front of where 11 Roundhouse Road is, where Lisa and Anna lived, under their mailbox, which was a developmental, there's a mailbox for all of those units in that one part of development, he put what would be a boom box, I would suggest you the colloquial way would describe it as a boom box, which had a radio and an iPod or an iPad or something, a device that can play songs, that he had put certain songs on, battle tunes, as he would describe it. But this also had wires to make it look like if it had were to be moved, it would explode. You'll also hear that he left other devices around the entire Roundhouse area, again, to slow the police response for what he was going to do. You hear, as I described, how he entered the house, how he climbed up the stairs, threw the shotgun down, went in, and revealed himself. You hear that he knew these two individuals, and they knew him, because he also was in the Coast Guard, and they had served together when they were stationed in Kodiak, Alaska. You'll hear that he was, at that point, basically demanding that they apologize, and that they were profusely apologizing. You'll hear that this wasn't enough, though. You hear that he stepped from the room, and at that time, the two women grabbed the mattress that was on the bed in order to try to protect themselves, to hide behind. He came back in, and he shot 15 times from the handgun, 11 rounds of which were to enter the body of Lisa Trebnikova. And I told you about the 4 times that Anna was with him. He then left. You hear how he was dressed, how he had battle fatigues on, how he had a number of large capacity magazines on the belt that he was wearing. You hear he had a knife on the belt. You'll hear how, after he left, that Lisa had already tried to call 911 on her phone. So that line had already been established. And that how Anna then tried to communicate with the 911 service. And you maybe hear what was going on at that time while she's trying to do that. You'll hear that Mr. Loya, having left the room, 11 Roundhouse, then begins to go and make his way around the Roundhouse Road circuit. You hear there were things discarded at different places. There'd be some handcuffs, and the handcuffs would be the type that were the Ziploc kind of handcuffs. You hear that there were other devices that were left around the area. You hear that he ended up at 77 Roundhouse Road, which the way that Roundhouse Road is designed is the so-called high ground. You hear the police were dispatched, and the fire department were dispatched. And at that time, the police didn't know if there was 1 shooter, 2 shooters, 3 shooters. Now they began to try to get around the burning car to assist Anna, who was on the phone with the 911 operator, begging for them to come and help her. You hear how the police would split up, 2 women, 2 of the other, get around the car. And that as while the police were approaching an area near 77, a parking lot down on the ground, which would be below where Mr. Loya was, he began to open fire at them. And that he hit police officer from Bourne, Jared McDonald, in the lower back, out from that scene, into an ambulance. And you'll hear how the police also had to get to 11 Roundhouse to care for Anna. Anna survived, and she'll be here and she'll tell you her observations about what happened. You hear how Mr. Loya eventually discards at 71 Roundhouse Road basically the weapons that he had with him at that time, which included a rifle, a handgun, a number of clips that were high capacity, in other words, held more than 10 rounds, knife, and such things, and then walked out in order to turn himself in. And you'll hear that he also took off a GoPro device. And I say GoPro, yes, I would say Coca-Cola or Kleenex. I think it was actually a movie, but it was a camera in which he could record. No audio, just video about what happened. And you're going to be able to see that. And that it was working when he was in the bedroom. But you're not going to be able to see everything that you want to be able to see that will tell you everything that happened, because whenever he had his hands out with the gun, his arms would be blocking the view of the camera. But you'll be able to see enough, I suggest, to get a good idea of what was going on. You'll hear that he eventually walked down the street and turned himself in. And he was arrested by the police. And you'll hear about what was found on his person when he was taken into custody. You hear he was brought to the one police station, and he was interviewed. And you're going to hear about what he says during that interview. You're going to hear how he admits that he did this, and he's going to tell you why he committed this crime. This was really a revenge killing against Lisa Trebnikova. And you're going to hear about a supposed incident that happened in Kodiak, Alaska, where Mr. Loya, and the only evidence I would suggest to you that comes from this would be from Mr. Loya, claims that he was sexually assaulted, and you'll hear what he is saying his sexual assault is, and that he held a grudge pretty much from that point on, and that he targeted her. You'll hear that in October of 2014, that once Mr. Loya, you'll hear that, I'm sorry, to step back a bit, you'll hear that they were stationed in Kodiak, and eventually they were transferred to other places. That Lisa and Anna were transferred to Cape Cod. Mr. Loya was transferred to Virginia. And that he found out where Lisa and Anna were living, through use of the internet and such. And that he got online, and he went to some, I believe it's called Zillow, a service that's offered on.
Sorry to shut that clip down early, but we're going to go live to the Loya courtroom. There is a problem with the audio. We apologize to you, but we want to make sure that you get to see this live coverage now that the jury has returned from their site inspection. To the courtroom, live now.
To do something? Is it fair to say? You were not here because I think I think we all have. That's something. Let me ask you this. When you were caught out, and you noticed that as you described as silhouette, is that correct? Yes, sir. Did you hear that person, or is it fair to say that the silhouette was a human being? I saw a firearm. Okay. And did you recognize who that person was? No, it's a silhouette. Okay. It's a easily visible silhouette of the person. Okay. At any point, did you recognize who that person was? No. I'm sorry? No, but obviously, so it's an officer. You took it as an officer? Like you described when you met her? Okay. When did you recognize that it was a police officer? Just upon examining the stance and silhouette. Okay. And when you saw the stance and silhouette, when did you actually discharge your firearm? I think he was watching the silhouette moving toward me. Okay. So when he was moving towards you, you were discharging your firearm, is that right? Correct. And while he was moving towards you and you were discharging your firearm, you knew at that time that it was a police officer. Well, there never ever a positive that was a police officer. But you thought it was based upon the way he was crouched down and no one did I see it in a badge or in a patch or anything. Okay. Was it dark over there? No, yes, it was dark as over the parking lot. Okay, well, I believe from, I remember correctly, there was street lights parking not that far, so it was dark, yes. But you did see a silhouette, and you did see a firearm, yes. That was pointed at you. There was the movements of this person, officer, the movements of the raised firearm. Okay. And while he was advancing or coming towards you, coming in your direction, you continued to fire? No, basically fired. Once there was 4 shots, and then shoot. Okay, and when you discharged 4 rounds, is that fair to say? Approximately? That's what you think? Yes. Okay. What did you do after you expended the 4 rounds? I treated behind walked back up on the full patio and was sat there on the chair. Okay. And at some point, did you discharge any other firearms? Okay. And what happened next? I sat there and realized, well, obviously I was doing scenario. I'm sorry, I was doing scenario in the first place, but it was just one of those, I had to sit here and wait for him to come take me out. Okay. And then what happened? I walked out. And then what happened after you walked out? I stood in the light, moved my camera, put some snow in it. And then what happened? Officers came by, well, then I walked forward, officers, there's a dog pound one, kind of, that the LawNewz handle, sat down, I was in, kind of first. Okay. And then you were subsequently placed on cruise, was that right? Yes, sir. And then you were transported to the police station? Okay. Now, from what I'm hearing from the police officers, there may have been a car that was on fire? Correct. Okay, can you tell me what all you know that car was on fire? Okay, you had knowledge of how that fire be able to clarify? I guess therefore, I guess that the park started to give us some time to get to that. Okay, so what did you do that day? You see the pocket sideways in the road? Correct. And did you do anything else to that vehicle other than just parking there? You lit it on fire? What message did you park that vehicle, sir? Do you recall? Right back. And how was the position? So it was basically blocking the roadway? Right. And you say that you lit that car on fire? Right. Can you describe to me how you did that? I had charcoal in the car and I threw flares front and back. Okay, so you threw the flares in the front and back and did you immediately? That's okay. And then you proceeded to the young house? And to back it up again, prior to your arrival there, where were you coming from? Were you coming from an address in the state of Massachusetts or maybe Quality by the Long Bridge? And when did you arrive at that address? Tuesday. And where were you coming from prior to Tuesday evening? Okay. So you recall where you were staying in 101? So is it fair to say that prior to going to this address this evening, you left 101, room 101, all in and born? Correct. Okay, so do you still have the belongings still at 101, Okay. Are there any other firearms? Are there any ammunition or anything of that nature? So the only thing that's in that right now, so to speak, would be your clothing. Your clothing, hardware, or the secondary part of evidence, somehow this is lost, the USB drive I have. Okay. The maintenance and switches we have battery charger. Okay. Now, did you have any other ammunition on you? Ammunition holders, magazines? On my pants, had 2 13 magazines. Okay. And then my jacket pockets, 2 magazines. Okay, so you had 2 magazines still. Were they fully loaded? Yes. And what were the purposes for carrying the extra magazines? For a long run. For a long run. Okay. So, prior to your arrival there, well, let's say prior to your arrival from Virginia to the following year, you traveled from Virginia to the following year. Where did you purchase the firearms? Firearm. They're all still purchased. The receipts are at home. Okay. As far as the time frame goes, how long did you purchase those firearms? It was 2013 December. The shot brand is 2011 fall. Okay. Just in October, that's a captain. Okay. The 22 rifle was February. Those firearms were into? Yes. You did that purchasing from someone else. Was that the shotgun was the last purchase as battery military exchange? Okay. The other, the AR, was a FFL. Okay. Sure, FFL. So that purchase had a went back on jack. Okay. So they were legally purchased, is what you're telling me? Yeah, just like last year, so. Okay. Now, prior to Tuesday.
Jurors, I have another matter to take up, a case from Nantucket that I have to turn my attention to for the next half hour or 45 minutes. So I'm going to send you out for lunch. Please be in your jury room ready to go at 2 o'clock. I'll bring you down and put you to work. Thank you. Court, all items adjourned. transcript notebook stay on the chairs, please. Sorry? All right, jury's out of the room. Counsel, anything further at this time? No. All right. Let's set up the courtroom for Madison, please.
Welcome back, everyone. We were just live in the Loya courtroom. The jury had returned from a site inspection, and we were just watching the interrogation video being played for the jurors. We apologize. We know that the sound was a little off, but hopefully you were able to actually capture some of that testimony and some of that video. That interrogation video, a very key piece of evidence in this case. During that interrogation, the defendant said that he had been abused by the victim, and that seems to be some sort of motivation for the crime. How will that impact the defense of insanity? Well, only time will tell. How a jury will decide. But right now I'm here with Pierre Gooding to break this down a little further. Pierre, as an attorney, we just watched the jurors come back from a site inspection. We talked a little bit about the import of that. So in this case, there's a lot of evidence pertaining, excuse me, to the exterior of the building. Yeah. Tell us a little bit about what they saw.
Absolutely. So during the site visit, I imagine that the jury was taken into the home, into the exact spot where the crime was allegedly committed, so that the jury could get a sense as to where the victims were standing in relation to the defendant, what exactly occurred, in what moments. These sorts of aspects that are very important as the case unfolds, because this is what both the prosecution and the defense are going to be laying out for the jury over the course of the upcoming trial. So for the jury to have the opportunity to see it firsthand will make it much easier to grasp sort of what the situation was as it unfolded. What's most damning, and we talked about this a little bit earlier, is the fact that on the site visit, the facts aren't an issue. So when the jury sees where this actually unfolded, I believe it's going to be very emotional, because all they have to determine is whether this person was able to appreciate the criminal nature of his actions. But besides that, there is no two ways of looking at this. We know that one victim was shot and killed, that another victim was shot, and that an officer also at the scene of the alleged crime was also shot. So it's going to be very difficult as this jury comes to the site or comes back from the site to not be highly emotional and highly charged in a way that's going to be damaging for the defendant.
Yeah, Pierre, I think you make such great points, and thank you so much for picking up for me while I had a brief allergy attack. I have seasonal allergies, everyone. I apologize. Probably other people are plagued by this, but every once in a while it gets you. But you made some really great points. One of the factors that's going to be really important here is that area outside the house, just as you said. We just listened to the prosecution's opening. I'm going to hit some key points here that are probably going to overlap with what the jury saw when they were at that site inspection. So the prosecution focused on the fact that the defendant made these bombs to prevent law enforcement from accessing the property to render aid, that the defendant shot 15 times. He had multiple magazines in his belt. He shot a police officer in the lower back. No doubt they're going to see the area where all of that occurred in the house and in the exterior. Also, we have the GoPro. Now, some of that video was covered because the defendant's arms were in the way, but that's going to put some context to what they saw inside the house. We also have that car, that burning car, And we have that the killer went through the house layout on Zillow to learn where to go. So there's no question, once we're talking about the Zillow, what was the accuracy of the Zillow search as compared to the house? That's going to be a factor. That exterior area, the placement of everything. And the question is, how does that speak to his mental capacity?
Yeah, so how does it? What you just said is very important for this case. What happened before with the defendant setting up the car as a roadblock and setting up surveillance into the victim's home. This shows a level of planning that the defense is going to have to counteract. Because it's not just, as you said before, insanity in the moment. They're going to have to say that this individual was insane from before the time that he wrote his manifesto to the time when he set up these roadblocks so that help could not arrive, to the time after this alleged murder occurred. That's a lot of time for an individual to not sort of understand the criminal nature of his acts. And so it's not just a matter of what happened in that moment. The scene of the crime and the circumstances of the case make it so that the argument has to go back much farther in duration.
Absolutely. That's going to be a key factor. As you said, you're going to have to justify all those actions from the time that the planning began, which seems like it's with the manifesto.
Yeah.
Through the time when you are actually leaving the premises. And we're talking about not only the GoPro, we're talking about a camera in a tree and all this pre-planning that's really going to undercut that insanity defense. Here's another fact, and I just noticed this during the prosecution opening, which we've listened to a couple of times, but with each time I pick a new nuance. Sure. In this case, the defendant shot 15 times, and also the victims grabbed mattresses to protect themselves. And sometimes when you have a murder case, you don't have any real account of what happened. You have reconstruction experts come in and say, based on forensics, based on reports, based on everything that we have inside this house, this is what we think happened.
Yep.
This case is different.
It's different.
We know what happened here.
And Missy, think about the power of that testimony from our second victim. Sitting or being in the room, standing on the witness stand, no pun intended, but standing there talking about what actually occurred is going to be very challenging for the defense. It's going to be emotional testimony. Her spouse was slain. There will be that emotional aspect. The jury will get to look into her eyes and see the amount of pain that has been caused. And so you are absolutely correct that level of testimony as a first-hand account is going to be very troublesome for the defense.
Absolutely. That's going to be a really tough road. I think that the best defense here is exactly what you said. It's kind of painting this picture, painting a picture of somebody snapping and then all of these acts being part and parcel of that. Let's talk about another interesting thing. As you just mentioned, all the witnesses in the courtroom are standing. The judge is very particular about the evidentiary rules. In some courtrooms, you see that they're a little more lax when it comes to laying the foundation for certain evidence, stuff that's absolutely going to come in. This judge is very, very particular, very, very by the book. How do you think that's going to impact some of the other evidence that comes in? Because as we know, the judge is really the one with the most leeway to make those determinations about what comes in and stays out of the courtroom.
Oh, absolutely. I think here there won't be as much of a fight about what comes in and what stays out because, again, these facts are not in dispute. The defense and the prosecution agree on what actually occurred, which means that the items that will eventually turn into exhibits, I do not believe there'll be a lot to fight about. This case will come down to which expert the jury believes and whose testimony the jury believes, and that will be outside of fighting over the rules of evidence, which is actually a good thing.
Yeah, definitely. The one thing we might see some controversy over, which we often do, is experts.
Yeah, absolutely.
Expert
Yes.
reports, what reports come
Yes.
in, whether or not this person's actually an expert in the field. We don't know yet what types of experts, other than most certainly mental health experts, psychologists, psychiatrists, those types of experts will be at play. But we don't know if there'll be other types of experts that may come in to speak to perhaps trauma. Very often in
Exactly.
cases involving abuse, or in cases where abuse is a piece of the puzzle, you will see a trauma expert come in and talk about how being a victim of a traumatic event can actually lead to not being able to understand your consequences. In some cases, it's PTSD. In some cases, it's other diagnoses. Do you think we're going to see something like that here?
Absolutely. And remember, the defense is just trying to introduce reasonable doubt. And so, of course, you are going to have an expert come on the stand. And if the defense is able to prove that a sexual assault occurred, then the next step is for the expert to say that this assault contributed substantially to the individual not being able to appreciate the criminal nature of his act. And so you have to put it together piecemeal, but certainly those experts will be paraded on the stand for that testimony. Without it, it starts to look very much like either an act, just a malicious act, or a revenge killing, both of which set you up for a first-degree murder charge where you'll be confined for life. So that's what the defense is trying to circumvent, and that's how they're going to have to do it. But it's not going to be easy. It's a very challenging case to put together, even in that capacity.
You're right, Pierre. And we just heard the prosecution's opening statements. We were revisiting that while we wait for court to be back in session. Right now, the jury is at lunch, so we're waiting for them to come back. I'm going to chug a little water to make sure that I don't have any more issues with allergies. And in the meantime, since we've just really broken down what the prosecution had to say, we're going to revisit the defense opening statements. Now, make sure to listen clearly here, because again, this is really where the defense is setting out how they intend to raise reasonable doubt throughout the case, how they intend to show that the defendant did not have the mental capacity to be culpable for this crime. So after we revisit the defense opening statements, we're going to break it down again with Pierre Gooding.
Folks, good afternoon. We spent a few days together once again. I'm Drew Segadelli, and I'm here on behalf of Adrian Loya. Being a part of what we did the last few days, you saw the pains we've taken in the impalement process. The theory behind that obviously is we want to seek you heard the judge use the impartial jurors. We likewise would like to believe that any preconceived bias or prejudice are essentially left at the courthouse steps. But we don't ask any jurors ever to set aside their common sense. Like Mr. Glennie, his honor told you about keeping the open mind, I will likewise do the same thing. But I will ask you throughout the trial to still utilize your common sense and exercise that gained through life's experiences. Now, it's a challenging case. We're going to be applying the same principles of law and so forth as one would in a trespassing case or a capital case of this nature. But it is still challenging. And as we all know, utilizing common sense, and the judge will tell you eventually that the Commonwealth, and you've all heard this, bears that burden of proving the case. That proving the case beyond a reasonable doubt. And I'll just submit to you early because we're not arguing now, we're just hopefully helping you. But it is a significant burden. And you heard somewhat in the impeachment process that it isn't only proving beyond a reasonable doubt that that fellow did these terrible, tragic acts. It's not only that, but they also must prove beyond a reasonable doubt that at the time of misconduct, that he, as a result of mental disease or defect, did not appreciate the wrongfulness of his conduct, or that he could not conform his conduct to the requirements of law. I'll submit to you, some people use the expressions, who done it? Though this isn't the case, you're going to see an abundance of evidence, a great majority of which came from that fellow, my client, as he wrote a 265-page document about this plan. As he wrote letters to Lisa, some 23 pages before this event. You're going to hear that some of this plan, or this planned mission, could have gone as long as 16 months, the planning stages, that it was meticulously planned, meticulously detailed in each and every nature of it. Listen for that. Not only that, what he left in the paperwork, but when speaking with the police officers on 2 different occasions for hours. And you'll have the opportunity to hear that. And I'd ask you to pay particular attention, not only to the acts that occurred on his birthday, somewhat unusual, February the 5th, 2015, his 31st birthday, but the specific detail in the 265 pages, in the detailing it to the police, because I'm going to suggest to you that's all going to wind in to his disease of defect. That's not the legal label. It ultimately will be for you, but how do we go there? Now, keep in mind, as the judge has instructed you, the defendant doesn't have to do anything. Why is that? As the judge told you, he is presumed innocent. But I think the evidence is going to show you and lead you down a particular path. And we have witnesses, and I anticipate you'll hear from witnesses in this case. And some use the expression expert witness. That's really when you become judges. It will be for you to determine whether or not you accept or exclude. They're not given any grace because they're termed this or they have a particular profession that could help give credence to their opinions. But you'll hear from I anticipate you'll hear from a Dr. Daniel. Let me step back. Experts, as one utilizing common sense could assume, they base their opinion on their database or the accumulation of all information they can utilize to draw their conclusions. Well, you'll hear from Dr. Daniel, you'll hear everything he utilized to form his opinion. Not only were there police reports and 265-page documents, and police report speaking to collateral families, speaking to the Coast Guard and their investigation, speaking to the lawyers perhaps, he spent some 43 hours, the evidence will show you, with Mr. Loya. Some 43 hours. And he's going to suggest to you that he suffers from a significant mental disease or defect that both deprived him of the ability to perform his conduct to the requirements of law, and we go with that, what's called the McCool standard, appreciate wrongfulness, conform conduct. He's going to suggest to you, and that standard, ladies and gentlemen, is given to us in the alternative. So it's not and, it's appreciate wrongfulness or conform conduct to the requirements of law. Dr. Daniel, after spending all that time, you have the ability to praise him like us. You'll also hear from, and I'd submit to you, Dr. Daniel has a significant amount of experience, but you'll also hear from a Dr. Martin Kelly, who has a long history in testifying and so forth. You may hear such evidence that he has testified in some 300 to 400 cases. That he was originally hired. The court eventually asked him to speak to Mr. Loya, and he spent better than 9 hours with Mr. Loya. And pursuant to his training and experience, he's a psychiatrist. He said, somewhat of a different label, where Dr. Daniel gives some type of delusional label, but it's a significant mental disease or defect. Dr. Martin Kelly suggests that it's on the autism spectrum, in fact, perhaps a high-functioning Asperger's. And because of that, and likewise, he suffered from a delusional base on that particular day. We're focusing on that day, February 5th, because it's at the time the conduct is committed, that he could not, Dr. Kelly could not conform to the requirements of law because he was in a delusion. In fact, it was in his mind, Dr. Kelly, I believe the evidence will show, it was a good against evil scenario. You're going to hear what was occurring in his head in that particular day. That's why I said it's a challenge. This case is going to be a challenge. It's not the whodunit, but when I look seriously at this testimony about what was going on, what was he doing in the planning stages, what caused him, what motivated him to do all this, and what was it as a result of. You're going to hear from there's a Dr. Holtzman, I believe, who works for the state, not wholly convinced of a mental disease or defect that would give or deprive somebody of the ability to conform their conduct. But what we'll also look to, and the evidence may show you that Dr. Holtzman didn't have that database I talked about, police reports. I don't think he had the ability to see Dr. Kelly and Dr. Daniels' reports. So one might suggest his foundation was not sound enough. Eventually hired years after this, and I would just submit to you at this time an opening statement. The most important time is the events sometime after 2 a.m. on February the 5th. In fact, the first call came into 911 at 2:11. Mr. Loya was taken into custody at 2:48, so there's roughly 36 minutes that's involved here that we're going to be looking at, and I'm going to ask you to keep an eye on. But you're eventually going to hear, I believe the evidence is going to show you, you're going to hear from a Dr. Ida, who was eventually hired to give an opinion. And she gave an opinion. Once again, I'd ask you to look at what type of database does she have. She had a period of better than 8 months to go and visit and see Mr. Loya. One would hope to assist her in her evaluation of him. She never took that opportunity. But in light of that, she'll suggest to you he could conform, or he doesn't meet the standard. When I can say that, I'd ask you to keep an open mind, as the judge will tell you. That's ultimately up to you. Those folks, even if they're labeled the experts, it's going to be up to you, ladies and gentlemen, to make that determination. And she never, Dr. Ardisha never availed herself of that. Again, the whodunit aspect, keep an eye on where it came from. The vast majority came from Mr. Loya, because it's part of that delusional base we're starting with. And I'll eventually ask you to look, when you deliberate, look at all of that evidence to see that first aspect of that burden that Mr. Glennie has to carry from start to finish. Yeah, we'll probably get over that first girl, but the second, at the time, and that's why it's such a challenge, at the time that he could conform himself, that he appreciated the wrongfulness, and I would submit to you at this stage that he could not. And after that challenge, one will submit that the Commonwealth could not get over that burden of proving the case beyond a reasonable doubt. Thank you.
Thank you, counsel. Surely. Jurors, anytime I go to the sidebar, you're welcome to stand and stretch if you wish. Just don't discuss them.
Hello, everyone. We're still waiting for the jury to return in the Loya court. Right now, they're on their lunch break. This morning, they were on a jury viewing at the site of the crime. So right now, we're just waiting for them to return so we can continue on with testimony. We did see the jury back in the courtroom watching the initial police interrogation video of the defendant. Definitely some compelling information there, and we'll see more testimony on that later. In the meantime, while we wait, we've been reviewing the prosecution and defense opening statements. We just watched the defense, where there was, of course, a focus on reasonable doubt. We also heard a little bit about the defense of mental disease or defect and the capacity of the defendant during the commission of the crime. So here we have an interesting situation because the facts really aren't at issue. We know that he committed this crime. The question is, did he have the mental capacity to be found culpable of the crime under the law? To break this down a little bit further, we have Pierre Gooding. He's an attorney. Pierre, so we just heard the defense go through their opening statement, and no doubt the focus are those magic words, beyond a reasonable doubt. There's reasonable doubt here. And the defense was really focused on that. They mentioned the manifesto, which is interesting. It's almost one of those situations, and I know they tell you this when you're a first-year lawyer.
Yep.
Don't ignore the bad facts. No. Address them head on. Make sure to get them out there and prepare your defense to them right away. Do you think that's what the defense attorney was thinking? Because the manifesto seems to be a bad point for the defense.
Oh, absolutely. The defense, as you said, is trying to get out ahead of the situation. We know that 250 pages is going to be introduced to the jury, sort of outlining how this crime was going to be committed and the reasons why. And when you start talking about rationale, it moves very quickly away from a criminal insanity defense. And so I believe you're absolutely right. The defense team has to proactively counteract this manifesto and say, look, it's out there, but it's out there because this individual had already snapped. He had already lost the ability to appreciate the criminal nature of his acts. He wrote this up as a part of a larger issue of not being able to control himself. It's a very difficult case and argument to weave, but it has to be done because it's the only one the defense has. In terms of reasonable doubt, we know beyond a reasonable doubt that this crime occurred or that the act occurred itself. The only issue is, did the defendant have the capacity to understand what he was doing at the time when it occurred?
Pierre, and I think that we're all on the same page there. What you said is completely right. The defense attorney definitely was trying to make those points together. We heard during the opening statement the talk about reasonable doubt, talk about the mental disease or defect, talk about the manifesto, all looped in with that discussion of capacity and whether or not the defendant knew what he was doing was criminal conduct. So that's really going to be the fact that the defense is going to hone in on. And you're right, you're talking about what period of time, the protracted period of time that the defense needs to focus on. The defense brought up the fact that there's Asperger's or autism, possibly. I wasn't sure if that was a good strategic move out the gate. I don't know.
I mean, the key is to introduce every element that could possibly open up doubt, because if you look at these facts in isolation, very little doubt occurs. If you look at the setting up of IEDs prior to the incident, if you look at the surveillance of the victims prior to the incident, or strapping on a GoPro onto your person, all of these indicate a level of planning. And so what you have to do is introduce all of these at the same time and say, look, we know that this would look like planning, but there's really something in the background going on. And in the background is the fact that this individual is autistic. That isn't enough in and of itself, but if you pair that with the sexual assault and the expert testimony saying that the alleged sexual assault led to this individual not being able to control himself or control himself, it's a very, very long, convoluted argument, but it's the only one that they have. As you mentioned earlier, the facts are what they are, and the defense was only presented with the case as it unfolded. So their job is to make sure that this jury believes that despite all of these facts in isolation, this individual wasn't able to control himself because of a mental defect or disease. Very difficult, but considering the circumstances, that's all they have.
Right, always difficult, always a difficult defense, the insanity defense, because of what we said before. It's very hard to convince a jury that someone shouldn't be held responsible for their crime because of a mental disease or defect. And so when you have facts that tend to show that somebody's lucid, somebody understands what they're doing, or at least knows the actions that they're taking are going to lead to the murder of another person, it's an uphill battle. But let's talk a little bit more about insanity defenses generally, mental disease and defect, what that means. So obviously, just being diagnosed with some sort of mental health issue does not necessarily mean that you reach the legal definition of insanity. Also, there's the issue of what happens. So say the jury says, okay, we buy it. We don't think that you had the capacity to commit the crime.
Sure.
That doesn't mean you walk out on the street like a free
Absolutely.
person, it's not the same as an acquittal.
Absolutely. So two things. One, it's a very high bar to prove a mental defect or disease, even though we know in this case that Massachusetts has to proactively show that this individual was sane at the time that this incident occurred. It still is a very high bar on purpose. It's set up in the law so that this is defense you must present expert testimony, and you must show that this individual wasn't able to appreciate the wrongfulness of his act at the time that it occurred. It is not enough to just show that the individual was out of control or that the individual didn't want to do this. It has to be something where he either couldn't control himself physically or was not able to understand that this was wrong in real time. And the problem here are the extraneous factors, the facts that were going on outside of the house, where these IEDs, these fake IEDs, were set up to throw off the police officers and throw off medical assistance. That shows a level of planning, a level of understanding the wrongfulness of your acts. But that's where we're going to have to go. It's set up to be difficult on purpose because we don't want every individual claiming insanity, but this is where the defense is going to have to go.
Right, absolutely. This is really the only option at this point. I want to go through some other interesting testimony with you, and unfortunately, we weren't able to carry live testimony yesterday, but we do have some recaps of what happened. Specifically, this is the testimony of Police Chief Dennis R. Woodside. Now, he was a patrolman, and he is one of the patrolmen that was working with him is the one that was shot in the back. That's Jared McDonald. So obviously, in this case, there's a whole other element. You have the horrific story of the victim who is deceased. You have her wife who was severely injured, and then you also have an injured police officer. So there's stake in this on every level. You know, when somebody shoots at law enforcement,
yes,
that's a very, very big point for the jury, and it's not looked upon very kindly. So here's an interesting piece of testimony yesterday. The chief asked the suspect if he was acting alone and why he did it. The suspect, this is the defendant, said he was alone and the victim had sexually assaulted me earlier and that he was dressed tactically. He pointed the police chief to a rifle he had stashed under the neighbor's deck. Yeah. I mean, this is all in his initial conversation, initial interaction with the defendant after the police were finally able to make it to the home. Yeah. So we're talking about a couple issues. Tactically dressed, that's how it was described. Assuming that's some sort of dressed for this event, dressed kind of in a military style. Exactly. Garb. Points to a gun that he had hidden under the neighbor's porch. Yeah. That's showing that there was clearly some foresight. I mean, if you need any more ammunition to show that there's foresight, there's another piece.
Exactly.
And then that statement, which I'm assuming came in as maybe a statement against interest because that could be hearsay. It doesn't sound like he was Mirandized first. It doesn't sound like this was part of a formal interview. It sounds like this was something said right in the moment. Absolutely. The victim had sexually assaulted me earlier.
Yeah.
I mean, Pierre, I know we've talked about this, but I'm so interested in this aspect because how do you get around that? I mean, this is revenge to me.
Exactly. So, Misty, both sides are going to use this fact or try to use this fact to their advantage. What the prosecution is going to say is exactly that. This has nothing to do with a mental defect or disease or ability to appreciate the wrongfulness of your actions. It's the exact opposite. This individual knew what he was doing. It was a cold, calculated revenge killing for something that occurred to him or that he thought occurred. Now, the defense is going to do the exact opposite. They're going to say that either this situation with the sexual assault was a tipping point where the individual lost the ability to control himself, or that when this never even occurred, and it shows the level to which the defendant was unable to ever control or appreciate the criminality of his actions because, again, if this sexual assault never occurred, how can he be lucid? So there will be on both sides arguments to be made about this circumstance, depending on how it plays out. But for both sides, this is a key fact. This sexual assault has levels and layers that have to be unpacked, and the jury is going to have to decide how it works into the analysis of this grave incident.
Definitely. And one other piece of the puzzle there is that he was described as calm, as we said before, which is interesting because when you're walking out of this type of horrific disaster, this horrible situation, this horrible crime, the defendant is very calm, and that will cut both ways. But at the same time, what do you make of this other piece of this case, which is the fact that Jared McDonnell, who is a victim and a police officer who is responding, was shot? So when you're engaging in a shootout with police, isn't that indicative that you understand that perhaps what you've done was a criminal act? If you're engaging in a shootout, is that because you're trying to get away?
Well,
trying to keep them from coming? I mean, I'm not sure how the defense is going to overcome that.
So the facts are the facts, but both sides are going to try to use these facts to their advantage. So the argument is misty. Well, at that point, you've lost control, and you don't know who's who. You've always worked with police officers. You've always been a cool, calm, collected member of society, and so at this point, you've snapped. You don't know who's who, and you're not able to appreciate anything about what you're doing, is going to be the argument that's made. I believe the jury will be taken aback at both the victim and the officer that was shot, and so there will be a lot of issues to overcome, but that's how these facts are going to be used. You're going to have to argue that at that point you had no idea who you're shooting at, and you've literally just lost all control of your senses at that point. Will the jury buy it? That's a completely different question.
Definitely. And when we're talking about that issue and his mental capacity at the time, as you said, we have this longer road that you kind of have to justify. But the question is, will the defense have a little bit of an advantage there because of the burden being on the prosecution? It's a little bit more difficult to prove somebody's sane than to say that somebody is insane. Now, again, it's in any state, with any form of the insanity defense, whether it's the McNaughton Rule, Model Penal Code, the Durham Rule, whatever it might be, those are difficult defenses because it's very, very hard to get a jury on board with eliminating culpability for a crime based on mental defect. But in states where the burden is on the prosecution, that means that the prosecution has to prove sanity beyond a reasonable doubt. So that's a little bit different. I don't know what we're going to see from the prosecution. I know we're going to see mental health experts at some point, either on the direct case or maybe in rebuttal to the defense witnesses. But I almost think that for the prosecution's direct case, I'm not sure they even need to put a mental health expert on at the forefront. They can just talk about his appearing to have planned this, appearing to have engaged in a shootout, which would tend to show that he understands the criminality of his conduct, talking solely about his actions.
Yeah, well, look, his actions, some would say, do speak for themselves, but this is a situation where I do believe you're going to want to have experts to elevate that argument to a level of professional, have a professional stamp of approval on this, because what you're saying is that at some point this officer, this Coast Guard officer, lost the ability to control his own actions, and the jury is going to have a very hard time going from A to Z without some medical experts stating emphatically that yes, this occurred at this point, at this juncture, and it led to these heinous crimes occurring. Without that, you ask a jury to say to themselves, this individual, upstanding member of the community for many years, was able to function in the Coast Guard, able to pass medical evaluations for many years, and now all of a sudden is unable to control his own actions to a point where he can't stop himself from murdering an individual and attempting to murder two others. That is a stretch. And so I think that even though the defense may be able to get away legally with not presenting experts, this is a case where it's definitely in their interest.
Yeah, I think you're right. And we know that the defense is going to have experts. I mean, I actually think the defense case is going to be primarily experts. Yes. When I think about what witnesses the defense might bring, you're going to have, as we spoke about, you're going to have mental health experts, obviously. You may have experts that may need to explain prior mental health records or explain that moment where this person went from being someone who was functioning well in society to someone who no longer understands what they're doing. I also think, as you pointed out, I think you're going to see a trauma expert, because if this trauma, if this abuse becomes part of the case, you'll see that very often a trauma expert will come on the stand, and you see this so frequently in cases of battered women's syndrome or any sort of case involving, very often it's husband and wife, it's spouses, it's people in relationships, either the man or the woman is abused by one or the other, and they don't act the way that you think they should act. But there's a reason for it, and trauma experts will explain that sometimes people are so detached from reality that they're not in their right mind, that other issues can actually trigger something that would lead them to not act the way that they would normally. And that's a big factor, because oftentimes a jury hears, well, if she abused you, why didn't you go to the police? Or something like that that would undercut the defense argument. But if you have a trauma expert, that could potentially tie up those loose ends.
Absolutely, and the expert could say, of course, a rational human being would do A, B, and C, but this individual was not in that right state of mind at that point. Now we know that the prosecution and the state has already deemed our defendant to be competent to stand trial, and so that expert testimony is sort of already there, and I'm sure they will have their state witness go on and corroborate that evidence, stating that there's no reason why this individual isn't competent to stand trial and shouldn't be convicted. But of course, the defense will put on their experts as well to counteract that testimony. And so you're absolutely right. This is going to be a battle between experts, and the jury is going to have to determine whether they believe that mental defect defense is a winner.
Yeah, and Pierre, another interesting fact, and the defense brought it up during the opening statements, and again, every time I listen, I've got to listen to these things multiple times, because every time I listen to those opening statements, I catch another nuance. In the opening statement, there was a focus on the fact that a mental health evaluation wasn't given contemporaneously at the time of the arrest or shortly thereafter, and the defense pointed that fact out, and perhaps that's to further set forth their argument that, well, hey, he was never given a mental evaluation at this time, so how can we actually speak to his state of mind then? There is a question as to whether or not he was knowledgeable about what he had done.
Exactly, and the time dynamic in this case is very important for both sides. For the prosecution, they're going to look at the days, weeks, and months leading up to this case, saying all of this shows a level of premeditation, shows a level of planning that's well outside of a mental defect or disease defense. This could not have been planned by an individual unless that individual was operating at full capacity, and common sense would lead you down that road. That's what the defense is going to say, and the prosecution is going to say the exact opposite. Look, no sane person could have planned this heinous crime. So looking at the same set of facts and really parsing them out two different ways, and having experts look at the same set of facts and parsing them out two different ways is really what this case is going to come down to. But for the defense, there has to be a mountain of expert testimony to counteract the clear facts here, because the facts, if the jury's looking at it, sort of speak for themselves, and they're uncontroverted. So that means that the defense is going to have to give the jury reason to let this man off with an insanity defense, which, going back to what we were talking about earlier, doesn't necessarily lead to this defendant walking free. From there, he would be involuntarily confined, and after 6 months, the judge would reevaluate, and every year after that, there would be a reevaluation to determine whether this defendant could then walk free after years. So this isn't the end of the conversation no matter what. It's the start of it, whether it's through civil confinement or whether it's jail time.
But we'll definitely be keeping an eye on this one throughout the course of the trial. Who knows? Maybe the defendant does have some smoking gun. We don't know yet. We're making a lot of assumptions based on what we know so far. But a lot of the evidence hasn't been out in the press yet. We're really seeing the evidence as it unfolds. There hasn't been a lot of leaking of some of those critical documents. For instance, the manifesto, we have not been able to find that yet. So there may be so much more to this case than we even know, and we will be watching, as you're watching, live from the courtroom. Right now, we're still waiting for the jurors to return from lunch. In the meantime, we're going to listen to the testimony of Officer Joshua Parsons. Now, he was a first responder on the scene. He has a description about this car that was set on fire, allegedly to deter first responders from being able to reach the victims. So we're going to listen to his testimony now while we wait for the trial to come back live.
Voice, could you state your name and could you spell your last name?
My name is Joshua Parsons, Parsons.
And how are you employed, sir?
I'm a police officer with the Bourne Police Department.
And how long have you served with the Bourne Police Department?
Roughly 5 years.
Now, drawing your attention to the date of February 5th of 2015, were you on duty on that date?
Yes, I was.
And what duty were you assigned?
I was assigned to patrol the Pleasant Space Center of Bourne.
And how were you dressed when you went for to do that shift?
I was dressed in our blue duty uniform, badge, gun belt.
And did you have a car, or were you with somebody else?
I was alone in a marked cruiser.
All right. Now, drawing your attention to at or around 2:12 in the morning, did something take place or happen?
Around 2:12, I was dispatched to Roundhouse Road for a reported car fire and a second report of gunshot victims at number 11 Roundhouse.
What did you do after receiving that call?
Drove to the scene and arrived with several other officers. And as soon as I arrived on scene, I saw a burning sedan parked perpendicular with the road, made it impassable for any vehicles or pedestrians.
Now, when you say burning vehicle, could you be any more specific?
The vehicle was fully involved. Windows were all blown out, tires were flat.
Okay, so
Burning as you could get without being totally burned out.
So it wasn't a minor fire. This was a totally engulfed car.
Fully involved, yes.
Now, you said that you were a police officer for 5 years up to today.
Yes, sir.
And would that Roundhouse Road area be part of your patrol at times, being a police officer in Bourne?
Yes, it is.
If I might approach, please, Aaron?
Please.
If you'd be kind enough to look at these two photos and just referring to what's marked as A, do you recognize what that is?
Yes, I do.
And what is that?
That is the Roundhouse Road condominium complex.
And that's taken from the air, of course.
Yes, it is.
In photo B, is that just the same area from a different angle?
Yes, it's from a different angle.
And would this be consistent with what the weather conditions were at that time?
Yes, very snowy.
You know how to offer this?
Offered.
Okay.
Exhibit 1.
May I publish it to the jurors? So that-
Well, you can show it to them. Well, let my clerk mark it. Jurors, anything that's marked as an exhibit, you're going to have in the jury room during your deliberations to examine to your heart's content. So if you just get a quick look at it in the courtroom, don't worry, you'll have it to look at as long as you want.
So now, when you just indicated that you came into the complex and there was a burning vehicle, could you point on the map as to where that would have been located?
You're blocking some of the jurors.
All right.
Yeah, you will.
The vehicle would have been parked approximately right here across the road, right near the bed.
Okay. And if you could just show that would be in photo B.
You right over here.
Thank you. And as these photographs show, that roundhouse complex, how many ways were there to get into it?
It's only single access. There's one road in.
And that car was blocking that access in egress?
Yes, it was.
So you drove with your cruiser to that area, and what happened?
Parked approximately about 100 feet back from the fire. There were several other vehicles there already from my department as well as fire department. Walked up near the vehicle with other officers. Immediately noticed that there was a object in the snowbank to the right near a fire hydrant. It appeared to be an IED of some sort.
Okay, what do you mean by IED?
Some sort of improvised explosive device placed in the snowbank near the hydrant. Looked like a couple of soda bottles filled with small items and then had wires on it.
Okay. If you be kind enough to look at this, or do you recognize?
That was the,
In photograph, that's what you saw when you were, right?
yes it is.
Assistant marker ID.
Mark for identification.
That'll be identification of the...
Jurors, when something's marked for identification, that's how we keep track of it in the stenographic record. Maybe it'll become an exhibit, maybe it won't. We'll have to wait and see.
In any event, exhibit, I'm sorry, item B, here, that's a current accurate depiction of how that looks, is that correct?
Yes it is.
So I move to offer B at this point as an exhibit, even on this until the whole thing is just a little
Then it remains for identification. You're not going to single it up. And frankly, if it's not in the exhibit, you turn it around so the jurors aren't viewing it. The jurors see what's an exhibit, not what's being marked for identification, until it matures, if it does, into an exhibit.
Taking the observation of that item, what did you next do?
At that time, we still needed to enter the complex because of the shooting victims in number 11. So we had a plan to split the two-man teams and go around the vehicle and the possible explosive device through the woods using either side of the road.
So what happened next?
Myself and another officer, we had gone to the right side of the road. Because of the snow and the terrain, we had to go about 50 feet off the road into a gully, through about 3 feet of snow, and travel up the road till we passed where the burning vehicle was, to our rights at this time. Then we entered back onto the road, about 75 feet past the burning car.
Okay. And were you able to see that burning car after it was no longer burning?
I did not see it after it was still burning the whole time I was there.
What's the next thing that happened after you, who was with you, do you remember?
Also the servant was with
Okay.
me.
So you guys came out on the other side of the car?
Yes.
What's the next thing that happened?
At that point, we moved up to a fork in the road where the road can either go, it's a large circular complex, and we were going to go to the right because the other officers, we had planned to go to the left. So we got up to the fork in the road and tried to find some markers for the houses, but in this case, the markers are short markers. They were actually in the snow. So we were kind of trying to get our bearings as far as where we were in the complex.
All right. So is it fair to say at that point you didn't know which way 11 was?
No, I did not.
Okay. So what happened next?
During that brief pause, I heard a short burst of gunfire, followed by a radio transmission from Officer McDonald stating that he had been shot in the back and that he couldn't use his legs.
And do you know where Officer McDonald was?
At that time, the last I had seen him, he was in the parking lot downhill to the right, to the left, sorry.
Okay, so when you had indicated that you had broken into two groups of two, was he in one of the groups?
He was in the second group of two. He was with Officer Leavenworth, and they had come through the woods on the left side of the road.
Okay. So what did you do?
At that time, I started to advance towards his position to try to render aid to him, and also look for the gunman that shot him. Because of the way the development's built and the way the snow was, we were walking down the side of the road under street lights, and we didn't at this time know where the gunman was. Realizing this and that we were putting ourselves in danger, we backed up the road, myself and Officer Lacerda, and there's a large metal dumpster just off the fork in the road, and we took cover behind the dumpster until we could get a better bearing on where the gunman was.
And what happened next?
At that time, the more backup had arrived, and radio transmissions could be heard that they were coming up through the woods, following the same path that Officers McDonald and Leavenworth had taken to get to his position and help him. And that's when several officers started shouting that they had a gunman coming out of the woods towards them.
And what happened next?
I saw a deputy in K-9 come out of the wood line, or correction, out of the parking lot where Officer McDonald had been shot. As he came out, he called for support of a long gun, or a rifle, in other words. At the time, I was carrying a rifle, so I advanced down the road to provide him cover as he tried to go towards the suspect in the road as well.
Did you see somebody at some point?
As I came down the hill, I could see a gunman walking down the hill with his hands up, and I could see, I believe it was troopers on the left-hand side of the road, shouting at him to keep coming forward and keep his hands raised.
And what happened next?
As I came down to the deputy in the K-9, we moved forward, and we took over command to bring the suspect down the road and prone him out in front of us, or have him lay down on the road so we could handcuff him, or I could handcuff him. At that time, I did that.
Okay, and then what happened?
After handcuffing him, I searched him for any sort of weapons or anything that could hurt myself or other people around me. I removed a large folding knife from his right front pocket. He had tactical style, like BDU style pants on that the military would use, and there are dedicated pockets in the front that hold rifle magazines, and he had a rifle magazine on each side. I also removed 2 smoke grenades out of one of the right cargo pockets, and 2 small devices that I believe at the time were detonators out of a left side pocket, I believe.
Okay, were you able to determine at some point whether they were or were not detonators?
I was later determined that they were not. There was some sort of internet brand rape alarm or something like that that would emit a loud sound and a flashing light when the button was pushed on it.
And what's the next thing that happened after that?
I took those devices and I put them in a snowbank near us, because at the time I didn't know what they were, and I took and dragged the suspect off the road into cover, into the parking lot, which is just to the left of where I was standing, so that we weren't in any line of fire. Because at the time we were getting multiple calls through 911 that were being relayed to us for a second gunman in the complex somewhere.
If you be kind enough to look into this bag, if I'm not approaching.
Council do not need to ask permission to approach you. Approach at will, and if you overstay, you're welcome. I'll be sure we'll be back.
Could you look at that and tell me if you recognize what that is?
That's the device, what we believe was a bomb that was placed in the snowbank.
What do you believe? It's the device you saw.
Yes, sir.
I would offer this one.
Offer.
No objection.
Next number exhibit.
I don't know if we would take it out and start to play this something else or just leave it as that.
For a moment, we'll identify it as an exhibit in that bag, and council, after you've had a chance to inspect all the exhibits, you may change the bags if necessary. All right, it will still have the same number. If it changes bags, it will be exhibit 2.
Hello, everyone. We're still waiting for the Loya courtroom to be back in session. The jurors are at lunch after spending the morning at a site inspection where this murder occurred. Right now, we were listening to some testimony of Officer Joshua Parsons. Officer Parsons was one of the first responders, and as you heard in his testimony, he had a lot to say about this car that was blocking the way into the house. Allegedly, the reason for the car's presence was to block first responders' ability to actually render aid to the victims. I'm still here with my friend Pierre Gooding. He's given us some excellent insights today. Pierre, thank you so much for sticking with us this morning through the afternoon while we wait for court to be back in session. So Officer Joshua Parsons, he had a lot to say here. Some of the big highlights: all these soda bottles filled with small items that had wires on it. These are the hoax bombs. Eventually, the defendant came down with his hands up, but not before a shootout. What do you make of this testimony, and how is this factoring into the prosecution's case?
Sure. Very damaging testimony for the defense. When you talk about setting up hoax bombs, fake IEDs around the premises to stop medical aid and police from arriving on the scene, what you're talking about is a level of planning that shows that you knew that this was wrong, and that you knew that help was going to have to arrive, and that you chose to ensure that help would take longer to arrive on the scene. You're going to have a hard time showing that you didn't know what you were doing when those are the set of facts that are being laid out.
Definitely. And what about this was a part that I really thought Officer Parsons articulated well. He said he had a tactical vest on, the defendant, smoke grenades, and other devices believed to be detonators.
Yep.
I mean, this is a full-out staging to make sure that law enforcement cannot get there. So back to the original point, if the definition of insanity in Massachusetts is that you don't know and understand the criminality of your conduct. If you're anticipating law enforcement's arrival, what in the world do you say that you didn't understand that your conduct was criminal? And again, I think that focus is probably going to be on that understand piece. Pierre, how do you see the defense parsing out those two things? Because the law is pretty clear, and I was looking up the Massachusetts law. It's not enough to just know what you're doing. You do not have to be completely out to lunch and not know where you are, what day it is, or something like that. You can know what you're doing. The question is, do you understand the criminality? So how do you make that distinction?
Yeah, I think the defense is going to have to come full circle and say, look at everything that happened. This was so over the top, so unnecessary to actually complete what it was the defendant wanted to actually do, that no sane person would possibly go through all of this. You could have just gone to the house, done what it is you set out to do, and gone on your way. So that's where the defense is going to take this. They're going to say all of this, the fake IEDs, the symphony music, the GoPro, all of this indicates that the individual actually had no idea what he was doing, because no one in their right mind would possibly come up with all of this. They would just go do what needed to be done, engage in those unfortunate acts, and move on with their life. Again, is it an easy argument? Absolutely not. Missy, you're absolutely right. There is a high bar to a mental defect, mental disease defense, and whether these circumstances play out to prove that is something that the jury is going to have to determine, but a very difficult case for the defense.
Very difficult, and a lot of expert testimony we anticipate will be a part of this. Let's go back to that other piece, because we were just talking about some of the first responders reviewing some testimony yesterday that unfortunately we don't have archived, but we were able to review it with our viewers and let them know what happened. A lot of the testimony yesterday revolved around the shooting of the responding police officer. Is this, look, this crime is heinous, okay? There's no ifs, ands, or buts about it. Someone has died and their partner was left wounded. Obviously, that's going to be emotional testimony there. Yes. But when law enforcement is injured in the commission of a crime, do you think that that's going to give that extra oomph to the jury? I mean, that is not looked upon kindly.
No, absolutely not. And you have to understand these are real world circumstances. This is a small town in a small community where these sorts of incidents don't occur that often. And so for an officer of the law to be shot by the defendant, that's not going to play well with the jury. And in terms of a mental defect, you're going to have to show that even during that circumstance, you had no idea what you were doing and that you were shooting a police officer, which the actions and words of the defendant slightly after this incident occurred makes it seem as though he at least knew where he was and what the situation was. So again, the facts, when you put them all together in totality, the statements that were made, the actions that were done by the defendant leading up to this unfortunate incident, make it so that the defense is going to have a very difficult case to ensure that the defendant doesn't go to jail for life.
You're right, and another piece of this is just the sheer brutality. So we heard a little bit about that. We heard that the victims were holding up a mattress in order to protect themselves from being riddled with bullets, that the two females, so the victim who actually died and her wife who lived but was seriously injured, both didn't have a pulse when law enforcement arrived. We heard that there was a set of handcuffs on the floor. We know that there were several weapons involved. We know there was a gun underneath the neighbor's porch.
Exactly.
You're talking about a very brutal crime. You're talking about someone who traveled to kill this woman. So again, reverting back to how the defense is going to play that aspect of the defendant as a victim of abuse, how is that all going to factor in when you're talking about the level of brutality?
Well, it's a circumstance where you say no sane individual could commit these crimes, and we know that autism is not an excuse or does not get you off for a heinous act. But if the individual was autistic and then was a victim of a sexual assault, and that was a tipping point that made this individual unable to understand what he was doing in real time, that is a very difficult argument that is layered, but it's where the defense is going to have to go. The problem is that this sexual assault that's been introduced in this case could lead the jury to determine that this was a revenge killing very quickly, as opposed to anything else. And so even with that defense, the defense team is going to have a large hill to climb up.
Yes, and I agree with you, Pierre, and that was my gut reaction. When I saw that statement, well, she abused me in the past, and I saw that there's an indication that in the manifesto there's some point made that this person, that they had an issue before, that this abuse that at the hands of the victim of the case, which we don't know if that's true or not. We have not seen that play out yet. But no matter what, I had the gut reaction that, hey, look, a case of retribution, a case of revenge, that is not an insanity defense. That is someone who clearly knows what they're doing. But the question is, could that, say that the defense goes through, they talk about this abuse, there's some indication that perhaps it happened. I don't know what evidence is out there. Maybe there is, maybe there isn't. Could that be used as a potential mitigating factor as opposed to part of a full affirmative defense of insanity?
Well, two different rounds. It's going to play out on the affirmative end. You must show that the defendant was sane at the time that he committed these alleged crimes. So there is that. But then on the back end, if the defendant is determined to be found guilty, well, now you have to have a sentencing hearing. And at that point, although a first-degree murder charge is going to carry life almost certainly, there may be a situation where you can get introduced the fact that this individual is dealing with some real challenges, and that's what led to this situation occurring. Ultimately, I believe that if the defendant is found to be guilty, he will receive life, and that there won't be a mitigating factor. This case is just too heinous, as you said, and that's why it's being introduced now as opposed to in the sentencing phase.
You made a really good point, Pierre, because there's two phases. You're talking about the criminal culpability phase. You're talking about whether or not the defendant is actually guilty of the crime. So hypothetically, say we fast forward to the end of this trial and the defendant is found guilty of first-degree murder. Well, now we go to the penalty phase. And in the penalty phase, some facts that are being introduced in the underlying case could double. And the prosecution would present aggravating factors and the defense would present mitigating factors. So it's very, very good point that some of this could come into play later or could factor into something else. Or the defense, maybe they'd ask for an instruction on a lesser included offense or something like that if they don't feel that the insanity route is going so well. So let's talk a little bit about that. How about defense strategy? So right now we know the defense is raising insanity. They're not contesting the fact that the defendant actually committed these acts. That's when you plead insanity, you say, yes, he did it, but he should not be held culpable. That's the hitch. So in this case, the defense has the insanity defense. We don't know if the defense has something up their sleeve. We know that from what we've seen so far, it looks like a tough road. Who knows? Maybe they have some smoking gun, something that's going to come out in the medical records that's going to make us change our mind. But the defense isn't obligated to stick with that for the remainder of the trial. They're allowed to propose alternative theories. So maybe the defense will do that at some point if they don't see the jury buying their case.
Oh, absolutely. And there's going to be a mountain of medical records to go through. There are experts that will come on the stand and determine whether this defendant was sane at the time that this occurred, but that's where this has to be taken. Expert testimony is going to need to be presented by the defense in order to ensure that they can get this mental defect defense raised in a level that the jury agrees with. In isolation, this looks like just a heinous crime, but if you start poking holes in the prosecution's case, calling into account this defendant's mindset over a period of years, there is potential. It is unlikely, but again, the defense has to go with the set of facts that it has, and this is the best that they have.
You're right. Well, Pierre, I hope you'll join us moving forward throughout the course of this trial as we cover it. We're obviously going to be live in the courtroom for the remainder, and we'd love your insights. You had such great thoughts to share on this case.
Thank you, Misty.
Thank you so much to Pierre for joining me for the past couple of hours. He has really given us some good thoughts moving forward with this case about how the defense is going to proceed and how the prosecution is going to prove their case. Right now, we're waiting for the Loya courtroom to be back in session. We anticipate that the jury will be back in the courtroom at 2 p.m., so make sure to stay tuned.